I work out of the Toronto offices of Samfiru Tumarkin, and I'm here as I have in the past today, hopefully to answer as many questions as you guys have, all things employment law related. I realize that the hot topic very much is still having to do with COVID-19 and is still having to do with COVID policies. So I'm sure we'll talk more about that as we go through today. But if you have questions that are not COVID related, but nonetheless have to do with the workplace or a contract you've been given to review, or you have a question regarding your exit from a company, get them in. And again, I'll try to answer as many as possible. I did want to start off today before we get into some of the questions with, I guess, what I'll call a list of employment law red flags. This is something that I actually talked recently about on a radio show, and I thought it would be helpful to bring it up again because there are certain red flags that I think employees need to be aware of so that they can take steps proactively and protect themselves, at that time or in the future if that is needed. So the first red flag that I wanted to bring up has to do with a situation where you're in the middle of your career or your time with a company, you're asked to sign a new contract. And it's not because you're getting a promotion, or it could be, I suppose, but you're just asked to sign a contract midway through your time or at some point during your time with the company. A lot of times people sign contracts like this, not really thinking much of it. For example, they might get a raise as a result of signing a contract. They might get a promotion as a result of signing a contract, or they may not get anything. And they're just being told, it's paperwork. We need you to sign it. Sign on the dotted line kind of thing. And then people go ahead and sign it. And they think they're getting a specific benefit, or they think they're not certainly getting punished at all. And so they don't think about it and they give the contract in. And people need to be aware, first of all, of anything they sign and understand it completely, because there are a number of occasions where individuals sign a contract, thinking, great, I'm going to get a benefit, but not realizing that there's one or two or three clauses or sections in that contract that actually will adversely affect you, negatively affect you in the future. Things that may not have affected you with the old contract that will now affect you if you sign a new contract. So if you're someone who's being presented and asked to sign a new contract, definitely get in touch with us. It may seem straightforward. It may seem sort of just like you're crossing T's, dotting I's, but there could be huge ramifications down the line. So definitely want to get in touch with us if you're in that kind of a situation. So that's one red flag, or one situation where sort of my suspicions or concerns might be raised. Another situation I wanted to mention has to do with people who are put on performance improvement plans. So let's take, for example, the scenario where you are approached by your employer and you're told that you're being placed on a performance improvement plan because the company is not satisfied with your performance. But let's say that you actually take exception to that you actually don't believe you're a poor performer and that the performance improvement plan is therefore unjustified. If you've got a good, case in that regard, if you've got evidence, if you've got information to, kind of oppose that performance improvement plan or oppose those criticisms that are being sent your way by the company, then you'll definitely want to do so, because silence will be, in many cases viewed as you accepting or agreeing to their critique of your performance. So you want to make that known, and you want to put sort of that kind of stuff in writing. If an employer puts you on a performance improvement plan and it's completely unjustified and perhaps threatens termination if you don't comply with the plan, then that could actually be grounds for what's known as constructive dismissal. And you as an employee may have an opportunity to essentially exit that situation and have it treated like you were terminated and like you're owed severance. And then depending on how long you've been with a company, your age, your position, et cetera, you could potentially be looking at a significant amount of severance. So don't accept performance improvement plans that are not correct, that are not accurate, that are unjust. You want to, as I say, raise your objection to it, because they being the company, may be relying on that performance improvement plan later on down the road when they decide to potentially terminate your employment. And they may try to terminate your employment without giving you any severance whatsoever, and use that performance improvement plan and those criticisms as their justification. So you don't want them to be able to rely on something like that, especially if it's not true. And you want to, make sure that those objections are heard and, again, heard in writing. So that's a second sort of red flag scenario that I often come across that people need to know about. I'll do one more and I'll get into the questions. This third one has to do with your employer saying that you're not the right fit for the job. So you're approached by the company, you're told that, they're going in different directions, or you're not the right fit, or you're just not suitable. And then they actually terminate you for just cause, meaning they don't give you severance, or they offer you a very little amount of severance thinking they have just cause. People need to understand that just cause is a very, very difficult thing for a company to establish. For the reason being that if it is established, you don't get any severance, generally speaking. So there's a very high threshold or burden that the company has to meet. And if there's any doubt as far as the reason why you were let go, or you question, what reasoning is given to you, and they're saying it's for cause, that's again something that you want to talk to our firm about and get a better understanding of, because there's a huge difference between someone saying they actually have cause and therefore a potential right not to pay you any severance, and not have cause and potentially have to pay you upwards of 2 years of severance. So don't just take their word for it. Understand that cause is a very hard thing to meet. A lot of employers like to throw that phrase around, that they have just cause to terminate. But the fact of the matter is, in most cases, they do not. And actually, this can apply to COVID policies, because employers are letting a lot of people go for just cause, and more specifically because they're not following the company's COVID policy. And it's going to be highly unlikely that the company is going to have just cause based on somebody's refusal to get vaccinated under that policy. So, to make things a bit more topical, if you are in that sort of a scenario and your employer is alleging that they have just cause to terminate you, definitely get in touch with us, because the odds are they don't, and that you're owed potentially significant severance. So those are sort of 3 red flags, yellow flags, whatever you want to call them, that I would be aware of if I were an employee, and I think all employees should be aware of, again, so that they can take more proactive steps and avoid something which may come down the road, or just protect themselves in that particular instance. But with that said, I'll get into some of the questions. I know you guys are sending lots of questions in, so I appreciate the questions as always. So just bear with me. I've got a question from Zay MCO Media on YouTube, and this person is asking or saying that their employer let them go after 3 years, but then they arranged for them to move to a new company where we had to reapply with less salary. And then there's a part 2 here that says the employer says they don't owe us severance because they found us new jobs at another company. Is this true? So if you're an employee and your employment is terminated without cause, let's say, there is generally an obligation on that employer to provide you with severance, or at the very least, whether it's your bare minimum entitlements, but potentially even more than that. So if you're being let go and that happens, you're generally entitled to severance. Now, there is an obligation on anyone who loses their job, let's say through a termination, to go out and try and find another job. So as much as somebody may be owed severance of a certain amount of money, that is in part dependent upon what happens in the future. So if someone finds a job a lot sooner, then they may not be owed as much severance. If someone takes, a lot more time to find a job, then they could potentially get more severance. But people need to understand that the only jobs that you're technically, or legally, I should say, obligated to look for after your employer lets you go are jobs that are comparable to the one that you lost. So if your employer lets you go, but then makes arrangements to have you join a new company with less salary, the question would be, how much less salary is it? So, for example, if you're making $50,000 a year and your employer says, hey, why don't you join this company making 25? You as the employee, the one who's been let go from the first job, you don't necessarily have an obligation or a duty to accept that role, because 25 versus 50,000 a year would not be seen as being comparable. If the job instead is paying you $48,000 a year and you were making $50,000 a year before, and there is an opportunity for you to take on this job, this $48,000 a year job, then depending on the other aspects of the job and depending on how comparable the job is in other areas, there may be, in fact, more of an onus on you to at least inquire about that position and look into it. Because if you are an employee and you're let go and your former employer believes that you could have found work sooner, or you should have found work sooner, again, comparable work, then that is a relevant factor to go into the equation. So, Zay MCO, I sort of partly answered your question just based on the information you gave. This may be something that you want to give us a call about. You were there for 3 years of roughly 3 years. So you could get 3, 4, 5, 6 months of severance potentially, depending on your particular situation. So I would say give us a call and maybe we can talk about it a bit further. But in short, there are sometimes situations where there is an expectation on someone to take on the next job. If it's suitable, if it's something they're comparable, they're able to do, obviously, that pays roughly the same or more. If not, then not so much. And then that may be a whole situation where your first employer who let you go would have to potentially pay you much more in severance. So give us a shout, but thank you in any event for your question. I got another question or comment in from JBK on YouTube. JBK is asking, how long can you be put on unpaid leave if you're not getting the vaccine and you're told by a lawyer you're not entitled to severance? So first of all, oh, sorry, JBK, you're saying I'm not entitled to severance because your work is located in TDSB, so Toronto District School Board. So first of all, if you're a unionized employee, I can't really be of much help, and take this advice for what it's worth, because I and my firm, for that matter, operate in the non-unionized context. So if you're a unionized employee, you work for the school board, first thing is to contact your local union rep. The collective bargaining agreement as well will set out a lot of the processes as far as whether you're entitled to severance, how you go about, pursuing the severance or filing a grievance. So if you're unionized, I can't really be of much help. If you're non-unionized, I would say that for you not to be entitled to severance is probably less likely than not. But it just depends at the end of the day on whether there's a government mandate in place that applies to, for example, the school sector. And so let's say, for example, there is a mandate that says you have to be vaccinated or maybe submit to rapid testing, and you don't want to do either one. Then there's a possibility that your severance entitlements could be affected. But if there is no mandate that says you need to be vaccinated, or there's no mandate that says you need to be tested, then it would be, in my view, unfair and legally unjust for that school to then put you on an unpaid leave of absence. Because what's going to happen is you're going to stay on this unpaid leave until, I suppose, you get vaccinated. That generally is the one way that companies will have people back in these scenarios. But if you're fundamentally opposed to getting vaccinated, and they're only going to return you if you get vaccinated or if COVID goes away, then you're just going to be in this limbo state for a while. And, it makes sense to take action sooner rather than later if that's the situation. Now, you're saying you're told by a lawyer not entitled to severance. I don't know specifically why, if it's because there was the lawyer was referring to a mandate, or if the lawyer was just saying anyone who doesn't get vaccinated under a policy is not entitled to severance. Because if it's the second thing, then I can tell you that's wrong. The vast majority of people who are losing their job or being put on an unpaid leave for not getting vaccinated are owed severance. There are a few exceptions, and there is some noise, happening with the federal sector context, although still no federal government mandate for the most part across the federal sector. But for the most part, especially provincially, it's not the case. So, JBK, I'd probably have to get a bit more information from you, but I wouldn't take the position necessarily that you're not entitled to severance, and that may be, again, something else you want to get in touch with us about, so we can talk about it a bit later in more of a fuller fashion. But thank you as well for your question. I've got a question from Nicole Fairman on Facebook. Nicole is asking, is an employee contract a legal document? How and would the company have it on file? Same with a hiring letter. So answer to whether the company would have it on file, I would say yes, they should have it on file. Contracts, hiring letters, warning letters, performance evaluations, these are all things that would typically be in someone's employment file generally. So the company will have a file on each employee, and those documents should be in there. If the documents are not in there, then I guess my question would be, why not? Is it because, 20, 30 years have passed? But typically they should have it. So that hopefully can answer that question. Whether an employee contract is a legal document, generally, yes, it is. If you've signed a contract of employment, whether before you started working or at some point during your employment with that company, there is a chance that the document you signed could have legal binding effect. So it would depend on what the specific issue is. Like, for example, you may be trying to say that there's a section of your contract that shouldn't apply, or that perhaps you didn't actually sign the contract, or perhaps you signed the contract, but you actually didn't receive any benefit for signing the contract. So there could be a number of issues or arguments you could make to say that there are aspects of it that shouldn't be enforced. But otherwise, generally, you're going to find that companies are going to say that whatever you signed, you agreed to, you're bound by, but don't think that's necessarily the case, because there are several ways of getting around these types of issues. And I guess without knowing a bit more information, Nicole, that's probably as best as I can say right now. If you do have any further questions or follow-up, feel free to give us a shout, and we'd be happy to probably set up a consultation to discuss further. But thanks, Nicole, again for your question. I've got another question or comment in from Tana, forgive me, on Facebook. She was let go because of a vaccine, been there 3 years. She's 41. She's going to be let go on the 30th, so about a week from now. Because of status, how much salary am I entitled to? We are private as well. So again, if you're being let go because of the vaccine, I guess the question is, are you being provided with any severance on your way out? Or is your employer taking the position that you're not entitled to any compensation because of the fact that you weren't vaccinated? If they're not giving you any severance or offering you any severance, then again, there's a very high likelihood that that would be incorrect of them to do so, and that you would be entitled to severance. Again, unless there's some sort of mandate, which is pretty rare for the most part. You've been there 3 years, early 40s. You're asking sort of how much you'd be entitled to. It would depend as well on what your position was, and how many jobs out there that would be similar or comparable are available. And it also depends on if and when you end up finding a job and sort of what that looks like. But for a 3-year employee, again, without knowing other pieces of information like what your role was, how much you were earning, etc., you could get 3, 4, 5, 6 months of severance potentially, depending on a couple factors. So nothing insignificant, definitely could be something worth pursuing. And if you're being let go on the 30th, it seems like they've given you at least a week's worth of notice, assuming they're going to pay you until then. But yeah, definitely want to get in touch with us. Whether you've been offered a severance package or not, it's probably the case that even if you were, it wouldn't be sufficient, which is often what I find anyways in my practice. So I would say give us a shout, and that may be something we can help out with, especially if your employer is taking the position that you're not owed severance or that you're owed much less than, the figures that I just cited. But thank you as well for your question. I've got another comment in from the Dreamer on YouTube, and this person is asking, if an employer emails you verbal or written warnings and you don't sign off on them, can it still be used as for cause termination in the future if they're building a case? So that's a good question. So it would depend on why they want you to sign off partly. So for example, I know a lot of warning letters nowadays, they'll say the company will ask for your signature, and right above your signature, it will say, I have read and I understand the comments or the criticism. So it's not necessarily saying that you agree to it. It may just be used to show that you received it. And definitely if you don't agree with it, you shouldn't, and you should make, again, that clear, especially if they're trying to build a case. I mentioned this actually at the beginning of my time today, in terms of, performance improvement plans and being put on these things unjustly. So you want to object to them in writing. And yeah, you don't want to necessarily sign anything that could be implied that you agree to it. But if it's just a matter of confirming that you received it, that's all well and good. I mean, at the end of the day, the company is still going to have to prove that what's, in these warning letters, whether it's verbal or written, is justified, is accurate. And if you've got information or evidence that essentially refutes that or speaks to the contrary of that, then you're going to want to kind of provide that to them. You're going to want to respond to them in that way, so that if they are thinking of building a case, they've now got to understand that, you're giving a particular response, and they're going to have to try to get around that, which then may make them not build that case. That could sort of prevent them from doing that. But if you don't make your objections known, then yeah, they could just build this case. You could be seen as accepting it or agreeing to it. But at the end of the day, it would be their onus to prove that you were such a poor performer or substandard in some way that they had a cause termination, down the line. If they're going to try to prevent you from getting severance, they're still going to have to prove that, but you're going to want to kind of paper your own trail, and maybe give them a second thought about what kind of path they really want to go down. But otherwise, happy to chat further about it if you'd like, and by all means, give us a shout and we can talk about it a bit further. But thanks for your question. I've got another question in here from Lena or Lena Cove on YouTube. They're asking, if an employer gives you 2 weeks notice to terminate, it cannot be a constructive dismissal, or it can be. So the short answer to that is yes, it can still be a constructive dismissal, or it may not be. So it's kind of hard to give you more information based on just that question. But do not assume that just because somebody gives you notice that your employment is ending, that there is not or has not been a constructive dismissal. And that could be a constructive dismissal for many reasons. A constructive dismissal, by the way, is where there's a fundamentally, significant change to the terms of your employment that you don't agree with. Very clear-cut example, your employer comes to you, we're cutting your salary in half. It is what it is, sorry, but you got to accept it. And then you say, well, hold up a minute. I'm not agreeing to that. I never signed anything that I agreed to that. I don't care if it's a business related decision or whatever, if it's in good faith. I agreed to make this amount, and you're saying you're going to cut in half. No, that's not acceptable. And then that could be the point that you were constructively dismissed, when they change your salary. Now, they could give you notice maybe 2 weeks later that you're going to be let go, but that doesn't change the fact that there was a constructive dismissal before that actually took place. So that's just one quick example of why someone giving you notice does not mean it cannot be a constructive dismissal. So don't think that. And if you are a long-term service employee, then it could be that they're trying to get rid of you, without paying you properly. So there's something else you want to get in touch with us about, and we can take it further from there. But thank you for your question. I've got another question. Again, thanks everyone. There's tons of questions coming in. I definitely won't get to them all, but I do recommend that you tune in to our shows later on in the week. We've got these live Q&As going in all the time, so just be sure to check out those shows and get your questions at that time. But I'm going to go on to another one from VS2015M on YouTube. They ask, what about just cause for dishonesty? If an employee was dishonest and it resulted in financial loss for the employer. So dishonesty, deceit, lack of trust, these are very serious things in a sense, because if you can't trust somebody, then they're much less likely going to be given a second chance or a third chance or a fourth chance, etc. If a company can show that the trust relationship between you and the company is just completely damaged and there's no going back because what you lied about or were dishonest about was very significant, and especially if it results in financial loss. I don't know what the loss is exactly. I'm not going to say that, it means you have no case, but dishonesty is a tough one. I'm assuming it's true. If it's not, then again, the company at the end of the day has to prove it if they're going to go down this just cause path. But it's a tough one. If they truly believe that there's dishonesty afoot, then it could be difficult. But I won't say that just because you're dishonest about something means that you're going to be let go for cause. So it as with everything, it comes down to the case by case basis. What was the dishonesty? Was there an admission of guilt, perhaps some sort of remorse expressed? Exactly what damage was caused by it, and sort of what communications were there between the company and the employee. So it kind of come down to a lot of that, but dishonesty and that kind of thing, that's one of the few instances where just cause could be established with just a single act. Whereas for the most part, you need multiple acts or examples of misconduct. But when it comes to honesty, it's a bit different. So again, not to say that you're shut out completely. Definitely give us a call. Maybe we can set up a consult and talk about it a bit further. Because those are also usually the cases where you get zero on your way out, and you could be looking at the difference between zero severance, which is what the company would love perhaps, and upwards of 2 years of severance if they can't make out that case. So that could be potentially a win big, lose big sort of scenario, but definitely give us a call if you have any further questions. Got another question in here from Julie Walter on Facebook. She's asking or saying that she was terminated before the vaccine was even mandatory. What are my next steps? Well, next steps, give us a call, because and you're not alone by any means. There are many employees, many of whom I'm helping right now, and probably will get many phone calls about in the future, who are being terminated when there's no vaccine mandate in place, when it's just the company's internal policy. The company is telling you that they have an obligation under the Occupational Health and Safety Act to provide a safe workplace. But besides that, there's no actual mandate saying all of these employees need to get vaccinated, and if they don't, this is what you can do to them. That just simply doesn't exist for the vast majority of industries. And yet I'm seeing terminations due to non-compliance with these policies happen so frequently. So Julie, next steps, get in touch with us if you're someone who's lost their job before mandates even put in place. Even if it's put in place later on, give us a call. And just briefly while I'm on that, if you're working, let's say, for a federally regulated business, and you've heard about the government's announcements about how they're looking to make things mandatory, vaccines, that is, maybe that's so, but it hasn't happened yet. So it's all about, in many ways, the timing of when you're let go, when you lose your job, when you're put on an unpaid leave of absence. Is there a mandate in place? Because if a mandate comes a month later, well, too bad, so sad for the company. They can't rely on that fact. The fact is that they let you go at a time when there was no mandate in place. So timing can be critical. And again, Julie, just give us a call, because there's a good chance you're looking at some potentially significant compensation, severance entitlements. That is my time for today, everyone. I realize there are another, 10, 15 questions. I appreciate everyone joining today. I'll definitely be back as I always have been, and I'll be here to answer as many questions for you as I can. But as mentioned down below there, we've got another session going on Wednesday with Mr. Samfiru himself, 1 p.m. We've got these things going on multiple times throughout the week. So just look out for us. And I just want to thank everyone for the time and enjoy the rest of your day. But do take care. All the best.